Hi, my name is Pallavi Pratap and welcome to my channel. Today I discuss one of the contentious issues in matrimonial law, which is that of overlapping jurisdiction and maintenance. The Honorable Supreme Court, in order to put a quietus to the issue, has very recently in Rajnesh versus Neha clarified as to when maintenance can be claimed under one or more of the statutes like Hindu Adoption and Maintenance Act 1956 or Section 24 and 25 of Hindu Marriage Act or Section 125 CrPC. A party is not precluded from approaching the court under one or more enactments as the purpose of each act is distinct. However, it leads to multiplicity of proceedings and conflicting orders. Let us look at the various enactments and statutory provisions. First of all, let's discuss about Special Marriage Act 1954. Now, Section 4 of the Special Marriage Act 1954 provides that a marriage between any two persons who are citizens of India may be solemnized under this act. Now, it is a secular legislation applicable to all persons who solemnize their marriage in India. As far as this act is concerned, maintenance pendent lite, which is Section 36 of the Special Marriage Act, provides that a wife is entitled to claim maintenance as far as litigation is pending if she does not have sufficient independent income to support herself and for legal expenses. The court typically determines the quantum of maintenance depending on the income of the husband and awards such an amount which may be reasonable. However, there is also a provision of permanent alimony which is provided under Section 37 and is granted at the time of passing of the decree or subsequently as well. A permanent alimony is the consolidated payment made by the husband to the wife towards her maintenance for life. Now let us look at what Hindu Marriage Act 1955 says. Now, Hindu Marriage Act is a complete code which provides for rights, liabilities and obligations arising from a marriage between two Hindus. Sections 24 and 25 make provision for maintenance to a party who has no independent income sufficient for their support and necessary expenses. This is a gender neutral concept and it is a provision where either the wife or the husband may claim maintenance. Now, the prerequisite is that the applicant does not have an independent income which is sufficient for her or for the male counterpart to support themselves during the pendency of the litigation. Here also, just as Special Marriage Act, Section 24 of the Hindu Marriage Act provides for maintenance pendent lite, where the court may direct the respondent to pay the expenses of the proceeding and pay such reasonable monthly amount which is considered to be reasonable having regard to the income of both the parties. Now, the proviso to Section 24 provides a timeline for 60 days for disposal of the application. This was inserted in the amendment which took place in 2001. And Section 25 of the HMA provides for permanent alimony. Section 26 of the HMA provides that the court may from time to time pass interim orders with respect to custody, maintenance and education of minor children. Let's now look at Hindu Adoption and Maintenance Act 1956. Now, this enactment was done to codify laws pertaining to adoption and maintenance amongst Hindus. Now, Section 18 of this act is very important because it provides that Hindu wife shall be entitled to maintenance by her husband during her lifetime. She is entitled to make a claim for a separate residence without forfeiting her right to maintenance. Now, the right of separate residence and maintenance would, however, not be available if the wife has been unchaste or has converted to another religion. And then there is an important distinction that needs to be drawn between HMA and HAMA and that is with respect to Section 18. Now, if you look at it, Section 18 of HAMA is available during the subsistence of a marriage without any matrimonial proceeding pending between the parties. However, once there is a divorce, the wife has to seek relief under Section 25 of Hindu Marriage Act. Now, under Hindu Marriage Act, either the wife or the husband may move for judicial separation, they may move for restitution of conjugal rights, they may move for dissolution of marriage, payment of interim maintenance under Section 24, and of course permanent alimony under Section 25. Now, whereas Section 18 of Hindu Adoption and Maintenance Act only provides a wife a maintenance right. There is important point, which is the right of widowed daughter-in-law, which is provided in Section 19, that says that a widowed daughter-in-law may claim maintenance from her father-in-law if she is unable to maintain herself out of her own earnings or other properties. Now, if she does not have her own property or earning, she can apply for maintenance. This can come from the estate that her husband has left behind, or from the estate of her son or daughter. Now, rights of unmarried daughters have also been provided in Section 20, where it says that maintenance of children and aged parents has to be provided. And Section 20 casts a statutory obligation on a Hindu male to maintain an unmarried daughter who is unable to maintain herself out of her own earnings or other property. Now, the right is absolute under personal law, which has been given statutory recognition by this Act. The court has noted variously that the distinction between the award of maintenance to children under Section 125 CrPC limits the claim of maintenance to a child until he or she attains majority. However, if any unmarried daughter is physically unstable or mentally abnormal, or there is an injury which is there and she is not able to maintain herself, then the father is obligated to provide for her, one, of course, till she attains majority, and this has been there only to provide a wider concept, which is including the marriage expenses as well. Now, looking at 125 CrPC, we see that it is maintenance not only for wife but children and parents as well. Now, maintenance under Section 125 CrPC can be claimed by a person irrespective of religious community to which they belong. So, the substantive disputes with respect to dissolution of marriage can be determined by a civil court or a family court in an appropriate proceeding under HMA. Now, what is the criteria for application under Section 125 CrPC? See, the purpose and object of Section 125 is to provide immediate relief to an applicant who makes an application under Section 125. And this is predicated on typically two conditions. One, the husband has sufficient means, and two, that he is neglecting his wife who is unable to otherwise maintain herself. In such a case, the husband may be directed by the magistrate to pay such monthly income or monthly sum to the wife as the court deems fit. Now, interestingly, prior to the amendment of Section 125 in 2001, there was a ceiling on this maintenance amount, which was a sum of rupees 500 in the whole. So, in view of rising costs of living and inflation rates, the ceiling of rupees 500 was then done away with, along with as far as the 2001 amendment was concerned. Now, Section 125 subclause 2, the court is conferred with the discretion to award payment of maintenance either from the date of order or from the date of application. Under the third proviso to the amended Section 125, the application for grant of interim maintenance must be disposed of as far as possible within the 60 days of service of notice on the respondent. Now, there have been cases especially by the Honorable Supreme Court, in which the court held that the object of maintenance proceedings is not to punish a person for his past neglect, but it is primarily to prevent vagrancy and destitution of a deserted wife by providing her food, clothing, and shelter by a speedy remedy. Now, since it is the sacrosanct duty of the husband to provide for financial support to the wife and minor children, the husband is required to earn money even by physical labor if he is able bodied, and he cannot avoid his obligation. It is only except if there is any legally permissible ground, then only such a thing can be avoided. This was held in Bhuvan Mohan Singh versus Meena in a 2015 judgment. Now let us come to the most important form of relationship, which is the live-in relationship that we've been seeing. The issue where the presumption of marriage arises when parties are in a live-in relationship for a long period of time, which would rise to a claim of under section 125 CrPC, came up in Chanmunia versus Virendra Kumar Singh Kushwaha. It was a 2011 matter where a man and a woman had cohabitated for a very long period of time. In the absence of legal necessities of a valid marriage, would such a woman be entitled to maintenance? Now, the court held that a man should not be allowed to benefit from legal loopholes by enjoying the advantages of a de facto marriage without undertaking the duties and obligations of such marriage. So, a broad and expansive interpretation must be given to the term wife to include even those cases where a man and a woman have been living together as a husband and wife for a reasonably long period of time. Although, of course, it demands a strict proof of marriage should not be a precondition for grant of maintenance under section 125 CrPC. Now, the court in this judgment also relied upon Malimat committee report on reforms of criminal justice system, which was published in 2003, which recommended that evidence regarding a man and a woman living together for a reasonably long period of time should be sufficient to draw the presumption of marriage. A law presumes in favor of marriage and against concubinage when a man and woman cohabit continuously for a number of years. Unlike matrimonial proceedings where strict proof of marriage is essential, in proceedings under section 125, it is not important as far as live-in relationship is concerned. Now let's just look at what the Domestic Violence Act has to say as far as maintenance is concerned, since it is on a separate footing from the laws which have been discussed so far. Now, the DV Act provides relief to an aggrieved woman who is subjected to domestic violence, and the aggrieved person has been defined by section 2A to mean any woman who is or has been in a domestic relationship with a respondent and alleges to have been subjected to any act of domestic violence. Now, section 2F defines something which is called as domestic relationship, which includes a relationship between two persons who live or have at any point of time lived together in a shared household when they are related by marriage or through a relationship in nature of marriage. This can also include adoption, or this could also mean living together in a joint family setup. Now, a very important case I feel was the Hiral Harsora versus Kusum Harsora matter, which came sometime in 2016. And in this matter, they actually included that the respondent could also be a female in a domestic relationship with the aggrieved person, not just a man. So section 3 of the Domestic Violence Act gives a very gender neutral definition to domestic violence, but it also says that physical abuse, verbal abuse, emotional abuse, economic abuse that has been inflicted by women is also included against a woman. It could also go on to include sexual offences. Now, women included was actually after the court struck down the term adult male and replaced it with the term person. Now let's look at the shared household and how the respondent was considered to be guiding as far as shared household was concerned. And if a respondent is read to be only an adult male person, then there are so many times that we see that a woman is inflicting violence over another woman. Then how is it that the entire concept of shared household would come into play? So therefore the court struck down the words adult male before the word person in section 2Q of the 2005 Act, and deleted the proviso of section 2Q as being contrary to the object of the Act. The expression relationship in the nature of marriage as being akin to a common law or a de facto marriage came up in consideration in Velusamy versus Pachayamal. This was a 2010 judgment where it was opined that a common law marriage is one which requires that although a couple may not be formally married, the couple have been holding themselves out to society together. The parties are of legal age. The parties must be qualified to enter into a legal marriage, including being unmarried, and the parties must have voluntarily cohabited and held themselves out to the world as being akin to spouses for a significant period of time. However, it is important to mention here that not all live-in relationships would amount to a relationship in nature of marriage to avail the benefit of Domestic Violence Act, and merely spending weekends together or a one-night stand would never qualify into a domestic relationship. Now, for a live-in relationship to fall within the expression relationship in nature of the marriage, the Honorable Supreme Court had laid down guidelines in Indra Sharma versus VKV Sharma in 2013, and it said that the duration of period of relationship, shared household, domestic arrangements, pooling of resources and financial arrangements, sexual relationship, children, socialization in public, and intention and conduct of the parties, these were determinants to show whether or not that live-in relationship could be considered as in line with that of marriage. And so we see that section 21D provides that maintenance can be granted under Domestic Violence Act to an aggrieved woman and children, and also anybody who is in a live-in relationship with someone. But this can also be in addition to the order of maintenance awarded under section 125 of CrPC. Now, under subsection 6 of section 20, the magistrate also has the power to direct the employer or any debtor of the respondent to directly pay the aggrieved person or deposit such amount with the court, which is a portion of the wages or salary or debt that was supposed to be accrued to the respondent, and this amount can be then given to the aggrieved person. Now, section 22 provides that the magistrate may pass an order directing the respondent to pay compensation and damages for the injuries, including mental torture. It can be emotional distress and the acts of domestic violence perpetrated by the respondent. Now, looking at section 23, that provides that magistrate may also grant an ex parte order, which can include an order under section 20 for monetary relief. Now, the important part is that the magistrate must be satisfied with that application which is being filed by the aggrieved woman, disclosing that the respondent is committing or has committed, or there is a likelihood that the respondent may commit an act of domestic violence. Now, coming to the most important contention, which is about the conflicting judgments on overlapping jurisdiction. Some high courts have taken the view that since each proceeding is distinct and independent of the other, maintenance granted in one proceeding cannot be adjusted or set off in the other. Now, for instance, Madhya Pradesh High Court in a matter called as Ashok Singh Pal versus Manjulata had held that the remedies available to an aggrieved person under section 24 of HMA, which is Hindu Marriage Act, is independent of section 125 of the CrPC. Now, in an application filed by the husband for adjustment of the amount awarded in the two separate proceedings, it was held that the question as to whether adjustment is to be granted is a matter of judicial discretion to be exercised by the court. There is nothing to suggest as a thumb rule which lays down as a mandatory requirement that adjustment or deduction of maintenance awarded under section 125 CrPC must be offset from the amount awarded under section 24 of the Hindu Marriage Act, or vice versa. On the other hand, we've seen that the Bombay and Delhi High Courts have held that in case of parallel proceedings, adjustment or set-off must take place. Bombay High Court, in a very well-reasoned judgment delivered in Vishal versus Aparna, had taken this view, and the court was considering the issue whether interim monthly maintenance awarded under section 23, when read with section 20 subclause 1 subclause D of the Domestic Violence Act, would be adjusted against the maintenance awarded under section 125 CrPC. Now, the family court held that the order passed under the DV Act and the CrPC were both independent proceedings, and adjustment or any set-off was not permissible. However, the Bombay High Court then set aside the judgment of the family court and held that any maintenance which was given under section 21D of the DV Act makes it clear that the maintenance granted under the Act would be in addition to an order of maintenance under section 125 CrPC or any other law for the time being. So, the issue of overlapping jurisdiction under the HMA and DV Act or CrPC has come for consideration before the Delhi High Court in many matters, and specifically where the court has held that maintenance granted to an aggrieved person under the DV Act would be in addition to an order of maintenance under section 125 CrPC or under the Hindu Marriage Act. Now, the legislative mandate envisages that grant of maintenance to the wife under various statutes. It was not the intention of the legislator that once an order is passed in either of the maintenance proceedings, the order would debar re-adjudication of the issue of maintenance in any other proceeding. Now, the court also held that under section 21D of the DV Act, the maintenance awarded to the aggrieved woman under the DV is in addition to an order which is passed under section 125 CrPC. Now, the grant of maintenance under the DV Act would not be a bar to seek maintenance under section 24 of HMA. The court would take into account an order of maintenance passed under section 125 CrPC or any other law for the time being in force. The mere fact that two proceedings were initiated by a party would not imply that one would have to be adjourned sine die. There is a distinct scope and power which is exercised by a magistrate under section 125 CrPC and that under DV Act. Now, with respect to the overlap in both statutes, the court has held that the issue whether maintenance under section 125 CrPC could be awarded by the magistrate after permanent alimony was granted to the wife in the divorce proceedings came up before the Honorable Supreme Court this year, and in a matter called as Rakesh Malhotra versus Krishna Malhotra, where alimony was passed, and the court held that the same could be modified by the court exercising its own power under 25(2) of HMA. Similarly, the Honorable Supreme Court has also considered a case where the wife instituted a case under section 18 of HMA after signing a consent letter in proceedings under section 125 CrPC. Now, she stated there that she did not want to have any further claims for maintenance against the husband. However, the Honorable High Court held that the proceedings under Section 125 CrPC were summary in nature and were intended to provide a speedy remedy to the wife. But an order passed under Section 125 CrPC by way of compromise or otherwise would not actually foreclose the remedy which is available to the wife under Section 18 of Hindu Adoption and Maintenance Act. Similarly, we've seen that the Honorable Supreme Court directed adjustment in a case where the wife had filed an application under Section 125 of CrPC and under Hindu Marriage Act. In the Section 125 proceeding, she had obtained an order of maintenance, and subsequently under the proceedings of Hindu Marriage Act, she got herself some alimony. Now, since the husband failed to pay maintenance awarded by the court, the wife initiated recovery proceedings. So, the Supreme Court held that the maintenance awarded under Section 125 CrPC must be adjusted against the amount awarded in the matrimonial proceedings under HMA and was not to be given over and above the same. So, coming to the operative part of the judgment that we've discussed, which is Rajnesh versus Neha, it is well settled that a wife can make claim for maintenance under different statutes. For instance, there is no bar to seek maintenance both under DV Act and Section 125 of CrPC or under Hindu Marriage Act. It is, however, important that it would be otherwise inequitable to direct the husband to pay maintenance under each of the proceedings. So, therefore, there is an important requirement that if maintenance is awarded to wife in a previously instituted proceeding, then she is under a legal obligation to disclose the same in a subsequent proceeding for maintenance, which may be filed under another enactment. And while deciding the quantum of the maintenance in the subsequent proceeding, the civil court or a family court shall take into account the maintenance awarded in any previously instituted proceeding and determine the maintenance payable to the claimant. Therefore, the Supreme Court has now held that to overcome the issue of overlapping jurisdiction and avoiding conflicting orders being passed in different proceedings, the applicant has the obligation to disclose previous maintenance proceedings and the orders passed therein, so that the court would take into consideration the maintenance already awarded in previous proceedings and then make adjustments or set off the said amount. Now, if the order passed in the previous proceedings require any modification or variation, then party would be required to approach the concerned court in the previous proceedings, and that is primarily all about the overlapping jurisdiction. I hope you will find the information that I have provided today useful. Do subscribe to my YouTube channel and like my videos, and don't forget to share them. Until next time, stay safe and stay knowledgeable.